Sometimes your best expert is your own employee. Protecting communications with your expert can be critical, but whether in-house or outside, consulting or testifying, your expert's notes of meetings with counsel, emails, and correspondence explaining the theory of your case can be used to undermine your positions if discovered by your adversary. Trial lawyer Catherine Ahlin of Maslin will discuss the rules governing expert discovery and show how best to protect those communications and work product from disclosure. Please welcome Catherine Ahlin.
Okay, this is a picture of what I should have done 15 years ago in about my second week of practice as a lawyer. It shows a group of people around a meeting table having a meeting in person. Could have done it by phone too, but that's not what I did. Here's what I actually did. A very important partner called me to his office and asked me to communicate with the expert witness in our case. He asked me to talk to the expert witness about a number of issues, about the strengths and weaknesses of the case, important documents that we had identified that we wanted the expert to look at, and the relevance of those documents in our mind to the issues the expert was going to opine on. I was very diligent, so I dutifully wrote down everything that the very important partner told me. I marched back to my office. I drafted a communication to the expert in an email, and I CC'd the very important partner and I sent it off. I felt pretty good for about 5 seconds, and then my phone rang, and the very important partner was very angry. I still didn't know what I had done wrong, but I figured it out pretty quickly. Of course, what I'd done was I created a discoverable communication to that expert, which an opposing lawyer could, at best, use to understand our view of the case, the strengths and weaknesses, the important documents. At worst, that opposing lawyer could use that communication to go after the expert's credibility, to suggest that I had somehow influenced the expert's work in the case. Luckily, the case was resolved very early on, before we ever got even into discovery, and certainly not expert discovery. I learned my lesson. The very important partner and I went on and had a very nice litigation relationship, and we all moved on. The rules were different then, and today this email would likely not be discoverable, although some of my statements in the email might cause a court to order its disclosure, even today. So we'll get to that, okay? But first, why are we talking about this? Cases are often won and lost through expert testimony. Your expert needs to stand as an independent third party who's offering their expertise, whether scientific, forensic, financial, or what have you, to show the jury what the evidence in your case means. They need to stand as an independent third party expert who can explain what's wrong with what the other side's expert is saying. If opposing counsel can suggest that your expert is not offering a truly independent, nonpartisan, scientific opinion, she may not be able to speak to the jury with the necessary authority. Communications, notes, or files allowing the opposing party to attack your expert's objectivity by arguing that you influenced your expert's work can hurt. Of course, obtaining those files and using them against the opposing expert, that can be a goldmine. So I want to talk to you about how you can protect your own expert so that you can go after the opposing expert and successfully have a credible expert to offer at trial. The federal rules were amended in 2010 to provide specific protections to 2 categories of documents, of expert witness documents, not all categories of expert witness documents. There are no absolute protections. Do not communicate with your experts as if there is no risk of discovery. Do not refrain from discussing with your experts the methods for protecting their work product and your communications with them. The first category that's protected is draft reports. So Rule 26B4B provides that the draft reports, regardless of form, are protected. their work product. And work product is defined in the rule with the definition we all understand. And the only exception is the exception to the work product doctrine, which is codified in the rule. And that's a very unlikely, high bar. It's an unlikely exception to get applied to your expert's work. So, within this framework, your expert's draft report, which they prepare and send to you, it's likely going to be protected. And your edits in that report that you send back to the expert, that's likely going to be protected as well. However, not all expert-created documents are draft reports. And most trial court decisions err on the side of disclosure with respect to documents that are not clearly part of the report. There are some leading cases in this area, and they all arise from this litigation that arose from a multi-billion-dollar verdict against Chevron Corporation in Ecuador related to some environmental remediation. The cites are in my written materials, but there are two circuit court decisions in the 11th Circuit and the 10th Circuit in which they evaluated whether personal notes prepared by the expert were discoverable, whether they were considered to be draft reports. And the court found in both of those cases that the expert notes, task lists, outlines, memoranda, and spreadsheets were not draft reports under the rule. Those were discoverable. There are a lot of district court cases from around the country, so it's a very fact-specific question, and it's going to be fact-specific in your case as well. If your document is not clearly a draft report within the meaning of the rule, you might argue that it is, because it's an outline of the report, or it's a task list that's part of the report, or it's analysis that ended up in the report. Again, in a Chevron case in the Northern District of California in 2012, the court found that the documents showing the development of the expert's opinions, including notes, task lists, outlines, memoranda, and spreadsheets, were discoverable. They were not draft reports. The court did protect a few worksheets created by the expert and the expert's assistants that they were going to use in the expert report. So how your expert talks about the documents that come from your expert's files are important. So I have some practice pointers for you on this. Number one, consider seeking a stipulation with the other side at the outset of the case. If you both agree that the reliance documents will get produced, but other than that, the expert files are protected, then you don't have to worry about any of this. Your expert's files are protected, the other side's expert's files are protected. You give up the opportunity to go after the other expert with respect to their files, but you gain the benefit of freely communicating with your expert and not having to worry about potential disclosure. Second, ask your expert witness to refrain from taking notes during meetings if you don't have a stipulation now. We'll talk about the other ways you can handle it. So their notes are potentially discoverable. But if you take a note during a meeting, if you create the task list that comes out of your meeting with the expert and then you send it to the expert, as we'll talk about in a minute, that's a communication that will be protected. Ask your expert to limit her use of internal working documents. Ask her to do her work in the report. The draft report is protected. So if she's doing her analysis and her underlying work in the report, it likely is not discoverable. And fourth, if your expert witness does conduct substantive analysis outside of the report, have her prepare it in a memo to you. Again, that instead of having it be part of the expert file that potentially is not a draft report, make it into a communication that potentially is protected. But remember, there are no absolute protections. There is the work product exception in the rule, and the trial court can go nuclear. And I'm going to give you an example of a nuclear opinion from the District of Oregon in 2013. In the deposition, the expert witness stated that counsel made changes to his preliminary draft report, and the expert witness couldn't identify what changes had been made. Now, I think that's sort of what the rule is meant to protect. It's the attorney's impressions that might be found in the draft report when it's going back and forth. But the court found that the document had to be produced. All the drafts had to be produced. And the court said at the hearing, so I know what the rule says. I also know that lawyers are not supposed to write their experts' reports or any portion of them. And if that's happened here, then that goes to credibility, and it goes to admissibility, and the expert has to answer the question. That's the Gerke case, it's 289 FRD 316. And as an aside, the court also found it was a Rule 11 violation for that lawyer not to have personally searched the expert's the expert's file before doing the Rule 26 disclosures and producing documents. So that's just a reminder that you always have to be working with your expert and assuming that it's possible that opposing counsel will be looking over your shoulder, that what you're doing with your expert is going to be disclosed, and you should communicate with them with that in mind. So the second category of protected work product with experts are attorney-expert communications, except communications related to compensation, facts or data considered by the expert, and the assumptions counsel provided on which the expert replied. So the practice pointer here is segregate your communications, providing facts, data, assumptions to your expert witness from the communications about the substance of the case. This is where, if the rules today applied, I could have gotten into trouble with my email to the expert back when I was a baby lawyer. Because I discussed the strengths and weaknesses of the case, that would be protected today. But I also talked about some documents we wanted the expert to look at and consider. And that might be considered to be a fact or data communication that needs to be produced. Maybe it would get redacted, the part that doesn't provide facts or data, but it might not. The same work product exception applies to attorney-expert communications as to draft reports. So I just want to talk a little bit about facts or data. What does that mean? The advisory committee notes provide guidance to indicate that the only communications that have to be disclosed conveying facts or data are those where you're actually offering factual information, but it doesn't mean it's just limited to reliance documents. It might, if you provide facts or data to an expert and the expert ends up not saying, I didn't rely on that, the court might still say that has to be produced because the expert considered it. The other thing that I want to point out is that the term facts or data, the advisory committee notes provide, it should be interpreted broadly, and they talk about it containing factual ingredients. Well, I think a lawyer emailing an expert witness and describing factual issues, a judge might consider that to be a communication containing factual ingredients, and that might have to be produced. Okay. Other than communications conveying facts or data and the other communications we talked about already, there are other communications that your expert makes that could be discoverable. And those are the communications that don't involve you. So if your expert witness communicates with another testifying expert or a consulting expert or an employee, those communications are likely discoverable. And that was the case in the Chevron cases that we talked about earlier from the 11th Circuit and the 10th Circuit. So again, this is a practice pointer. You are going to have situations where your expert witness has to talk to another expert witness in the case, a testifier or a consulting expert. It happens. They are going to rely on something. They need to take an assumption from them. They need to understand some piece of the other expert's work. So when that happens, have them do it in a phone call or in a meeting, or have them talk to you and then you can talk to the other expert and relay information back and forth, because then those interactions are protected. Also, the same goes for witnesses. If you've got corporate employees that the expert's communicating with, that's not going to be protected either. So have them do it in a phone call or a meeting. The protections for communications with experts, they flow to experts' assistants as well. So if you're talking to anybody in the expert's office, it's going to be protected. In the Chevron case in the Northern District of California, they actually extended that protection to communications within the expert's office, between the expert and the expert's assistants. I'm not sure if that would happen everywhere, but it would be a helpful argument to make. Okay, and then, so I just wanted to point out a couple of other cases, just to give you some other thoughts about how this can get applied. Communications, in this case, in the Western District of Texas in 2011, the communications exception didn't get applied. So it wasn't, the parties didn't argue that the communications between the consulting expert and the testifying expert were protected because they were work product communications. The court found that because the testifying expert didn't rely on the consulting expert's work, that the communications were protected. And then, I'm going to keep going actually. So let's talk about consulting experts. Consulting experts are non-testifiers. Their work is protected. That's the basic rule. But you still got to make sure you're covering your bases. So the first thing is, are you talking to a consulting expert? Do you know they're a consulting expert? A court's going to consider whether that person fits within the definition of the rule. Are they retained or specially employed by the party in anticipation of litigation or to prepare for trial? That's a work product analysis. When did your client anticipate litigation? When was the expert retained? Who retained the expert? What did they tell them about the retention? What did the expert do? What was the purpose of the work? Because, you might have somebody that got hired by a corporate employee to do some work and you want to call them a consulting expert, but they're really a fact witness. The same is true with employees. If you want to call an employee a consulting expert, then they have to be specially employed by that party to do that work. Was there a business or a commercial purpose or a litigation purpose for the employee's work? Who asked them to do it? When did they do it? We'll talk more about that in a minute because employees are a whole nother ball of wax. So with respect to consulting experts, when is their work discoverable? Well, it's discoverable under Rule 35B when they conduct the exams that are listed there. The work product exception applies to the work of consulting experts, and there are instances where I think you really could find that a consulting expert's work is going to be discoverable. When could that happen? It could happen when you have a consulting expert do some work and the conditions change after they do it, so that the other side can't access the conditions that the consulting expert did. For example, if you have a fire or an explosion, an accident at the client, and your consulting expert goes out and does an investigation, but you don't give access to the other side at that time, then that site is going to change, and the other side's going to be able to argue that they can't obtain the facts or opinions on the same subject by other means. So the practice pointer here is you've got to consider whether you can preserve the evidence, and if you can't, whether you should offer access to the other side at the time that your consulting expert does their work. And then, as we said already, communications between consulting experts and testifying experts could be discoverable. So this comes into play when your consulting expert is doing work that your testifier is relying on. They're doing the underlying data analysis and they're providing it to the testifier, and the testifier is going to testify about it. Well, then you've got to think that there's a possibility that because the testifier is relying on the facts or data provided by that consulting expert, that might need to be produced. Okay, with respect to employees, I just want to point out that employee testifying experts, your communications with them may not be protected. So employee testifying experts, the rule says that communications are protected between a party attorney and any witness required to provide a report. Well, employee experts are not normally required to provide a report. And so if they're not, there are decisions that have found that means that those employee experts do not have protection in their your communications with them. That could be devastating because let's say that you start out working with that employee expert and you do your investigation working with them, you get your discovery collected with them, you prepare for depositions with them, and you've communicated with them that entire time thinking that your communications are protected. And then they're a hybrid fact expert witness, you disclose them, and suddenly your communications with them are discoverable. So my practice pointer here is, please keep in mind at the outset of the case who your experts are internally and work with them with the assumption that there is the possibility that your communications with them will be discoverable. So, the rules do protect significant portions of an expert's file and your communications with the expert. There are a lot of unprotected areas, and you need to be mindful of that in working with your expert to protect those areas. And in some, life does go on. When you make a mistake your second week of practice as a lawyer, you can move on and have a wonderful career, but you do learn to read the rules before you send an email to the expert witness. Thanks very much.